Hello everybody, welcome to juriscentral.com online classes for law exams. So today I will be discussing with you the most important cases on corruption, and as well as I will be discussing with you the most important cases on cyber law as well for your upcoming UPSC, CBI, APP, Delhi APP and other related prosecutor exams. So let us start. So first I'll start with Vineet Narain and Others versus Union of India. Let me tell you, this is a most important case from the point of view of Prevention of Corruption Acts, as in this case certain guidelines were laid down as to the sanction that needs to be followed and how it is to be followed, and what is the importance of sanction before prosecuting any person under Prevention of Corruption Act. And this case law is also very important from the point of view of DSPE Act, Delhi Special Police Establishment Act. So let us see. So first I'll start with the facts. The Single Directive number 4.3 clause 3 under Prevention of Corruption Act 1988 was an issue in this case. As per the directive, if the officer was of the level of Joint Secretary or above in the central government, then prior sanction of the secretary of the concerned ministry or department would have to be taken before the Central Bureau of Investigation started an inquiry. Moreover, other officers were also protected. So this single directive was in issue in this case, and as per the directive, if the CBI wants to prosecute a person who is of the level of more than the level of or of the level of Joint Secretary in the central government, and others officer also fell in this category, like to the level of manager or CEO or executive of a nationalized bank. So I have already dealt with you the Prevention of Corruption Act in detail, and section 19 deals with the sanction that is required before prosecuting a person under the act. The Supreme Court struck down the directive while holding that the directive would be applicable if the investigation was being done by the CBI. Section 4 clause 1 of DSPE Act deals with superintendents. Would not be applicable once the state police carries out the investigation. The central government couldn't exercise any control and power to the investigation by the state police. So in this case, this single directive has been struck down by the Supreme Court, and it was held that section 4 of the DSP Act deals with superintendents, and it says that if the state police has started its investigation under this PC Act, then in those cases central government won't be having any control or supervision as to how the investigation shall be carried out by the state government. And also the court gave the following direction: time limit of 3 months for grant of sanction for prosecution must be strictly adhered to. However, the same may be extended by 1 month with the consultation of Attorney General or any other law officer in the AG's office. So this provision has also been inserted by 2018 Amendment Act. So this is the first case in which it was said that the sanction has to be given within a time limit of 3 months and extended by 1 month with the consultation of Attorney General. The ruling has become the law of the land by Article 141. So under Article 141, the Supreme Court has the power to declare or say its decision has the validity of law of the land under Article 41. So this is a very important case from the point of view of PC Act, because this is the first case which is actually dealt with the issues of Prevention of Corruption Act. Then next is Dr. Subramaniam Swamy versus Director CBI and Centre for Public Interest Litigation versus Union of India, and this judgment is delivered on 6th May 2014. And now we'll see these two case laws are actually connected, and they are actually delivered in the same judgment called Subramaniam Swamy's case. The main issue of contention in this writ petitions was the constitutional validity of Section 6A of the Delhi Special Police Establishment Act 1946. A particular section came to be inserted through Section 26 Clause C of the Central Vigilance Commission Act 2003. The insertion of this section came after the controversial Single Directive number 4.7 of Clause 3 of the Government of India was struck down in the case of Vineet Narain and others versus Union of India. So this case is actually connected with the Vineet Narain's case. As in the earlier case, the method of sanction, the procedure of sanction which has been brought by the single directive was actually struck down in the Vineet Narain's case, but the same has been revived again by inserting section 6A under Delhi Special Police Establishment Act by the power given under section 26 of the Central Vigilance Commission Act. As per section 6A of the Delhi Special Police Establishment Act 1946, a prior approval of the central government needs to be taken for enquiry and investigation of any offence alleged to have been committed under Prevention of Corruption Act 1988 by certain classes of officers. So the single directive and this section 6A has no difference, because again the government has revived the procedure of taking prior approval or say the prior sanction before carrying out any investigation or any enquiry, just like the same. The Supreme Court in its judgment laid huge emphasis on Article 14 of the Constitution of India. As per Article 14, every citizen needs to be ensured dual equality and it needs to be ensured equality and equal protection of law. So this judgment is actually hugely based on Article 14, which actually deals with or provides for equal representation and also equal protection before law. According to the Supreme Court, the aspect of intelligible differentia had been lacking in this section. A certain level of officers who were working with the central government were given protection as per section 6A, but the same level of officers who were working with the state government were not given any such protection. Thus the differentiation did not sound intelligible, as officers at both the levels, that is the central and the state, were involved in decision making. On this view, section 6A of the DSP Act has been struck down. So I actually missed out to discuss on this point that section 6 of the DSP Act no more exists. It has been struck down in this case, and the reason for this striking down is under section 6A, the protection only has been afforded to the employees of central government and to the rank of joint secretary and other officers. But there were no provision as to the protection of officers who are actually serving under the state government. And so the Supreme Court didn't find this section to be suitable or to be maintainable under this act, because there was no intelligible differentiation. That means the differentiation has to be reasonable. So there is an unreasonable discrimination between the central and the state government employees, and this is the reason why section 6 of the DSP Act has been struck down. Then the next case is Dr. Subramaniam Swamy versus Dr. Manmohan Singh and Anr, and the date of decision is 31st of January 2012. Facts of the case, let us see. The appellant writes several letters to the respondent number 1, Dr. Manmohan Singh, sought to accord sanction to prosecute respondent number 2, A. Raja, the ex-Minister for Communication and Information Technology, under the Prevention of Corruption Act 1988 for alleged grant of licenses in violation of Clause 8 of the Guidelines for United Access Service License issued by the Ministry of Communication and Information Technology, resulting in a loss of around 50,000 crores to the government. So this case is also a precursor to the 2G spectrum case. Then the questions presented. What are the questions involved? Whether a complaint can be filed by citizen for prosecuting a public servant for an offence under the Prevention of Corruption Act, because in this case several letters were given by the petitioner to the respondent, but no action has been taken, and Prevention of Corruption Act actually doesn't provide any power to the private person to file a complaint by itself. Then second, whether the authority competent to sanction prosecution of a public servant for offences under the Prevention of Corruption Act 1988 is required to take an appropriate decision within the time specified in Clause 1, Subclause 15 of the directions contained in paragraph 58 of the judgment of this court in Vineet Narain versus Union of India and others, the guidelines issued by the Central Government Department of Personnel Training and the Central Vigilance Commission. So this is also an issue, that whether the appropriate decision of like taking decision on a sanction should be taken within the times prescribed, which has already been laid down in the case of Vineet Narain. So the decision, there is no provision either in the 1988 Act or the Code of Criminal Procedure 1973 which bars a citizen from filing a complaint for prosecution of a public servant who is alleged to have committed an offence. The question of granting sanction for the prosecution arises not at the stage of cognizance but only at the time of trial. So in this case it has been held that there is no provision either in the 1988 PC Act or in the CE.P.C which actually bars a citizen from filing a complaint for prosecution of a public servant. That means a citizen can also file a complaint against a public servant under PC Act, and it also says that grant of sanction for the prosecution is actually not compulsory at the stage of cognizance, that means at the stage of inquiry and investigation, but it only comes into picture at the time of the trial. The Prevention of Corruption Act is a special statute which has been enacted to consolidate and amend the law relating to the prevention of corruption and for matter connected therewith. And it also says that this is a special act and it has actually an overriding effect to other similar laws. Here the principle expressed in the maxim, this maxim is important, generally a specialibus non-derogant would apply, which means that if special provision has been made on a certain matter, that matter is excluded from the general provision. Therefore, the provisions of section 19 of the Act will have an overriding effect over the general provisions contained in section 190. Section 190 CRPC actually deals with complaint and section 19 deals with the procedure of sanction, and because PC Act is a special act, this is the reason why it has an overriding effect on section 190. That means a complaint under PC Act can't be filed under section 190 of CRPC, but there is a proviso which the court has said. The court upheld the time limit for grant of sanction in Vineet Narain's case and further held that at the end of the extended period of time limit, if no decision is taken, sanction will be deemed to have been granted to the proposal for prosecution, and the prosecuting agency or the private complaint will proceed to file the charge sheet complaint in the court to commence the prosecution within 15 days of the expiry of the aforementioned time limit. So it actually added a point in the Vineet Narain's case, because in Vineet Narain's case it is said that the decision of sanction has to be taken in a time frame of 3 months, further extended by 1 month. But it says that if the time frame is completed and no decision has been taken as to whether sanction can be given or not, so in those cases it will be considered that the sanction has been given and a private complaint can be filed within 15 days after the expiry of the aforementioned time limit. Then the next case is R.S. Naik versus A.R. Antule, again very important case. In this case, the Supreme Court has reaffirmed that the prior sanction for prosecution is not necessary where the person in question has ceased to be a public servant under the public office alleged to have been misused by him. In this case, it has been held that prior sanction is not necessary in those cases if the person in the office has actually ceased to be a public servant. It has also been held in this case that the authority competent to remove a public servant should be higher in the vertical hierarchy to the person, as such authority would only have the information about the nature and work of the public servant and would be able to judge whether the public servant has abused his or her position or not. In this case, it has also been held that the person who is higher in authority to the person who is to be prosecuted, and also it has said that the higher authority person will be having the power to remove that person and also to make decision or to judge whether that public servant has abused his position or not while he was in the office. Then the next case is K. Veera Swamy versus Union of India and Others. Again, very important case law in the aspect of judiciary, corruption relating in judiciary. This case was one of the first cases to emphasize on the aspect of requirement of sanctions for prosecution in certain cases, but mostly dealt with such sanctioning required for the prosecution of judges. It was clearly held in this case that for prosecution of judges of the High Courts and the Supreme Court, the sanctioning authority should be the President, but the President could only give such sanction after consultation with the Chief Justice of India. So in this case, again, the question arose as to who shall be the sanctioning authority or whether any sanction is required for the prosecution of judges. So in this case, the Supreme Court has made it clear that the only sanctioning authority for prosecuting judges of the High Courts and the Supreme Courts is the President. But he has to give his sanction only after consultation with the Chief Justice of India. Then the next case is CBI versus State of Rajasthan. The issue is, can a CBI investigation into an offence be directed by a magistrate in exercise of his power under section 156(3) of the Criminal Procedure Code. So section 156 clause 3 of the Criminal Procedure Code, it actually deals with, like, if the FIR is not registered, then a complaint can also be filed before the magistrate to take cognizance of the offence which is cognizable and non-bailable. The Supreme Court held that. So the question was actually whether a complaint under section 156 clause 3 can be filed before the magistrate to direct the CBI to investigate into an offence. So in this case, the Supreme Court held that section 156 clause 3 of the Criminal Procedure Code empowers a magistrate to direct such officer in charge of the police station to investigate any cognizable case over which such magistrate has jurisdiction. It was held that magisterial power cannot be stretched under section 156 clause 3 beyond directing the officer in charge of a police station to conduct the investigation. Section 156 clause 3 only empowers the magistrate to order the officer in charge of the police station to investigate any offence, but it cannot be extended to give order to the CBI to conduct an investigation into an offence. The Supreme Court thus held that a magistrate cannot direct CBI to conduct investigation in exercise of his powers under section 156 clause 3 of the CRPC. Then the next case is State of West Bengal versus Committee for Protection of Democratic Rights. So this case is actually counter to the earlier case of CBI versus State of Rajasthan. In this case, a constitution bench of the Supreme Court has held that the Supreme Court and the High Courts have the power to direct investigation by the CBI in an offence, and for that purpose, the consent of the state government under section 6 of the DSPE is also not required. So in the earlier judgment, it has been held that the magistrate cannot direct CBI to conduct investigation into an offence, but in this case, it has been held that the High Court and the Supreme Court has the power to direct the CBI to investigate into a particular offence, and for that it doesn't have to take the permission of the state government, which is actually requisite under section 6 of Delhi Special Police Establishment Act. Then the next case is the recent judgment, and it has been decided just 3 days back by the Supreme Court. So this case is the Supreme Court ruled that person's bank account cannot be attached under the Prevention of Corruption Act, citing section 102 of the Criminal Procedure. So section 102 deals with the power of the police to seize any property which is actually suspected to be involved in any crime or suspected to be stolen. While allowing an appeal against a Karnataka High Court judgment, the Justices Sanjay Kishan Kaul and M.M. Sundaresh made the following observation. It is not possible to sustain the freezing of the bank account of the appellant taking recourse to section 102 CRPC as the Prevention of Corruption Act is a code by itself. See, like we have already discussed, like Prevention of Corruption Act is a special act, and it has an overriding effect to other similar laws. So the question was like whether police can attach the property of the accused under section 102 who has been actually accused in a crime under under PC Act. So the court answers no, because Prevention of Corruption Act is a code by itself. It's actually a separate act. It's a special act, and it has an overriding effect over the criminal law. Facts. So let us understand the facts. In this case, a charge sheet was filed against 14 defendants stating that they committed crimes punishable under Section 13 Clause 1 Subclause A and 13 Clause 2 of the Prevention of Corruption Act, which deals with criminal misconduct, as well as Sections 420, 465, 468, 471 and 120B deal with 34 of the Indian Penal Code. They were accused of committing a large-scale fraud worth rupees 56.37 crores in collusion with Bruhat Bangalore Mahanagar Palike officials and private persons. The only question before the Supreme Court was whether the appellant's bank account was attached adequately in the exercise of powers under Section 102 CRPC. So this is the issue. The state stated that they are in the process of making an application under Section 18A. 18A deals with attachment of property under Prevention of Corruption Act. So it says that it is already in the process of making an application under Section 18A because the previous authorization provided by the government under Section 3 of the Criminal Amendment of Ordinance 1944 was not in the form of a government order. So under Section 18A, the property can be attached in accordance with the procedure laid down under Section 3 of Criminal Amendment of Ordinance 1944. Here the state is actually stating that because the order was not proper, was not in the form of a government order, and this is the reason why they have exercised the power under Section 102 of CRPC. So the court has held, be that as it may, on that account it is not possible to sustain the freezing of the bank account of the appellant taking recourse to Section 102 CRPC, as the Prevention of Corruption Act is a code by itself. The court said allowing the appeal. So the court actually rejected the contention, and it said that the procedure of attaching a property shall be taken under the procedure laid down in Prevention of Corruption Act. Then the next case is Anvar P.V versus P.K. Bashir, very important case in admissibility from the point of view, or say in the subject of admissibility of electronic evidence. Deciding the admissibility of the secondary evidence pertaining to electronic evidence, the three-judge bench of R.M. Lodha, Chief Justice, and Kurian Joseph and R.F. Nariman Justices overruled the ruling of the court in State NCT of Delhi versus Navjot Sandhu 2005 case. So in this case, the Navjot Sandhu's case was actually overruled, and let us understand what actually held in the case of Navjot Sandhu's. The bench noted that the court in the aforementioned case omitted to take note of Section 59 and Section 65A of the Evidence Act, and hence erred in holding that irrespective of the compliance with the requirements of Section 65B, which is a special provision dealing with admissibility of electronic record, there is no bar in adducing secondary evidence under Section 63 and 65 of the Evidence Act of an electronic record. So let us understand. So Section 59 actually deals with facts of which oral evidence can be given, and Section 65A deals with the special provisions as to admissibility of evidence by way of electronic record, and Section 63 deals with secondary evidence, and Section 65 deals with the cases in which secondary evidence can be given. So in Navjot Sandhu's case, in plain and simple language, let me tell you, it has been held that the certificate which is required under Section 65B Clause 4 for admissibility of an electronic evidence is not required by virtue of Section 63 and 65 of the Evidence Act, as it actually neglects the Section 59 and 65A of the Evidence Act, which says that oral evidence as to the contents of any electronic record can't be given. So in this case, the Anvar P.V versus P.K. Bashir's case, the Supreme Court has held that this certificate under Section 65B Clause 4 is actually mandated. It's a mandatory rule, and it cannot be taken away because already there's a provision in the Evidence Act which has been given under Sections 59 and 65A of the Evidence Act. Overruling the legal position as to electronic evidence as laid down in Navjot Sandhu's case, the court applying the principle of generally a specialibus non-derogant, which means special law will always prevail over the general law. So the special law is Information Technology Act 2000, it's a special law and it always prevails over the general law. That means the other provisions of Evidence Act cannot be given more importance over the provisions which has been inserted by the Information Technology Act. He held that the evidence relating to electronic record being a special provision, the general law and secondary evidence under section 63 read with section 65 of the Act shall yield to the same. Then the next case is Shafhi Mohammad versus State of Himachal Pradesh. This is a 2018 case. The division bench of the Supreme Court held in this case that the requirement of a certificate under section 65B clause 4 being procedural can be relaxed by the court whenever the interest of justice so justifies, and one circumstance in which the interest of justice so justifies would be where the electronic device is produced by a party who is not in possession of such device, as a result of which such party would not be in a position to secure the requisite certificate. Then in this case, the Shafhi Mohammad case, it actually partially, or say it actually didn't upheld, but it says in support regarding as to what has been said in the case of Navjot Sandhu's case, and said that this certificate under section 65B clause 4 can be waived off in cases of national justice, or sorry, in the case of in the interest of justice. And it said that in the case if a party wants to produce an electronic evidence and he doesn't have the possession of the device, so and this is a reason why he cannot produce the certificate which is mandatory under section 65B clause 4. So only in those cases the certificate can be waived off. Then the next case is Arjun Panditrao Khotkar versus Kailash Kushanrao Gorantyal. So this is a 2020 case. So in this case, what already has been held in the case of Shafhi Mohammad has been overruled in this case, and that judgment was delivered by a 2-judge bench of the Supreme Court, and this judgment has been delivered by a 3-judge bench of the Supreme Court. And it actually said, it actually upheld the compulsory rule of producing a certificate under section 65B clause 4 in the case of Anvar P.V and P.K. Bashir's case, and it neglected the opinion or the division given in Shafhi Mohammad's case, and said in a reference dealing with the interpretation of section 65B of the Evidence Act that deals with admissibility of electronic records, the 3-judge bench actually held that the certificate required under section 65B clause 4 is a condition precedent to the admissibility of evidence by way of electronic record, as correctly held in by the 3-judge bench in Anvar P.V versus P.K. Bashir's case, and incorrectly clarified by a division bench in Shafhi Mohammad versus State of Himachal Pradesh. The court further clarified that the required certificate under section 65B clause 4 is unnecessary if the original document it itself produced. That's what has been held by Shafhi Mohammad's case, that it is not actually necessary if the original document itself is produced. Then the 3-judge bench in the present case holding the Shafhi Mohammad judgments to be incorrect. So in this case, these are latest judgment in which the Shafhi Mohammad judgment was actually held to be incorrect, and in their view it has been said the major premise of Shafhi Mohammad that such certificate cannot be secured by person who are not in possession of an electronic device is wholly incorrect, and application can always be made to a judge for production of such a certificate from the requisite person under section 65B clause 4 in cases in which such person refuses to give it. So it says that even if the person is not in the possession of the electronic device, still an application can be made before the court and can be requested to produce that electronic device along with the certificate who has the possession of it along with a certificate under section 65B clause 4. That means a person who is in possession of the actual electronic device can be summoned to produce the device, and also can be called to produce a device along with a certificate under section 65B clause 4. So this is the end of the session for today, and I hope you all have liked it. Do not forget to give a like, share and subscribe to the channel. So till we meet the next time, thank you and have a nice day.